Good. On the council table here in the courtroom, there's a couple of different flyers. It's for the flyer for the Community Mediation Center. I just want to make people aware that that's an option. Sometimes people, it works best for them to resolve their differences by not coming to court and make a joint decision. So there's information there on the tables, and also if you want to take a look on their website, I think it's Community Mediation Center, just another option. It looks like Mr. Brooks is present.
Amy Powers here for Miss Grandchamp Brown.
Thank you, Ms. Powers. And Ms. Height, I see that you're here also.
Good morning, Your Honor.
Great. And it looks like Ms. Grandchamp Brown is also present. Is that correct, Ms. Powers?
Yes, Your Honor. She's appearing by Zoom.
Okay, very good. So we're here today, at least my understanding is that there's a guardian ad litem order appointing the guardian ad litem, and it's set today as a review to make sure that the parties have made contact and there's good communication between each party and Ms. Height, and making sure payment is in place. So maybe I could first start with Ms. Powers, then hear, or maybe Ms. Height, we could hear from you first, and then Ms. Powers and Mr. Brooks.
Thank you, Your Honor. Yes, I have received return packets from both parties. I've met with both parties in person and also by phone several times. I've met Jaden, who is coming up on his second birthday pretty soon. My understanding is that mental health evaluations have been scheduled. I do have a couple of concerns I would like to discuss with the court. I don't know if you want me to do that now or wait.
Now's as good a time as any.
Okay, thank you. First, the good news is I don't see any safety concerns in either home. Both parents have stated that the other parent is a good parent. They have positive comments to make about the parenting of each other, which I find very positive. Both state that they want Jaden to see both parents, have contact with both parents. So there's no, at this point, substantive issues regarding the direct parenting practices of either parent. What my concerns revolve around are two issues that have already been addressed by the court. The first, they both settle into the extremely high level of boiling conflict between the two of them. The two parents have great difficulty discussing anything without it becoming a conflict, becoming divisive. Obviously, this is not good for Jaden to be hearing. And so in an effort to try to turn the heat down on that, there's a couple of things I would like to ask Your Honor to consider today. The first is third-party exchanges are in place. Ms. Brown transports Jaden with a third party over to Mr. Brown's home, and Mr. Brown has a third party in place to receive him. However, both parties are appearing at these exchanges. Ms. Brown gets out of her car, Mr. Brooks steps out of his home, and so verbal conflict ensues at that point. So I'm asking that both parties stay out of sight and out of earshot of one another, that Ms. Brown remains in her car, keeps her door closed, keeps her window up. Mr. Brooks remain in his home and stay out of sight of the doorway, keep the door closed, so that at the exchange, and I hate to be this specific, but I think in this case, Your Honor, it's needed, that when Ms. Brown arrives, her third party, which is a teenage half-brother of Jaden, walks Jaden to the gate of Mr. Brown's home. I'm sorry, Mr. Brooks' home. Mr. Brooks' third party receives the child there. No messages are exchanged. No real conversation takes place even between the third parties. That Jaden is then walked up the ramp to his dad's home and the visit takes place. And then the exact opposite thing happens when he's picked up. I believe that at that time, both parties described, one called it a shouting match, one called it a screaming match out of the home as this little boy is being walked back and forth. that is just not acceptable to me. The other issue that is also already in place revolves around getting our family wizard in place. The court ordered our family wizard to be put in place and with a shared subscription. So far, that has not been able to be accomplished. I think part of it is there's been conflict between the two, and they can't have a civil conversation about it. The other problem is when we were here last time, Mr. Brown understood that there was. I'm sorry, Christopher. Mr. Brooks understood that there was a waiver that was a possibility. He thought that waiver was coming from the county. I explained to him yesterday that that waiver is possibly available through our family wizard, and that is how he should access that. So he was going to do some research on that. Because of the high level of conflict, I believe that it is going to be in the party's best interest to have only our family wizard contact. The voice messages that have been sent to one of their phones have been divisive, have been threatening, and that just needs to stop. So I believe that making Mr. Brooks responsible for finding the waiver, if there is one, for getting our family wizard in place, and being wholly financially responsible for that, at least temporarily, we'll get that in place as soon as possible. There needs to be no verbal conversation between these two folks, at least temporarily, until we can get the mental health evaluations done and we can turn the temperature down on the extreme amount of strife that is verbally between the two. I don't think there's any threat of physical violence. I think it's all just emotional turmoil that has boiled up for now several months. And neither one of them has been able to find a way out of that, to step back. So I believe that these detailed recommendations that I'm offering you could help put a pause on all of that. The only way I can justify in my own mind saying that Mr. Brooks would be responsible is that Ms. Brown is responsible for all of the transportation at this time. So there is a certain amount of expense involved in that. I don't know that it balances, and I understand that this is temporary. I'm just kind of grasping for something that will keep Jaden from hearing and witnessing turmoil every time his folks are together.
Thanks, Ms. Height. As far as, so your recommendation is that Mr. Brooks pay the double subscription, if you will?
Well, it was to be divided 60-40 at one point, and it would make him responsible for the whole thing. And I don't know how much that will be with the waivers that could be in place.
And what's the rationale behind that?
Well, I don't believe that they can have a conversation to get it done. They have stepped up to the idea of it, but they have never been able to pull the trigger, and it's been weeks now to get it done. And I think that it is imperative that something happens to get this done immediately. If there's another way to do it with them each being responsible for a part of it, I'm all in favor of it. It's the only way I could think of that it could be done so that these phone calls that are coming into his phone regularly can stop, that there are no verbal conversations. Everything could be through our family wizard and could be overseen.
And in your understanding with our family wizard, I was under the impression that each party creates an account and then they make a reference to who the other party is, and then our family wizard pairs them together, and then they're each responsible. They can each put in their own payment information. Is that accurate?
That is accurate, yes.
Okay. And then, so what's the issue with then? What have you observed of why they, Ms. Grandchamp Brown and Mr. Brooks have not done that on their own?
I don't believe they understand how the system works. And so when they've talked about it, there's been misunderstanding. Also, Mr. Brooks has been waiting for that waiver that is obviously not coming from the county.
Right.
So if they can both pay their portions, I'm all for them both paying. I'm just looking for a way, Your Honor, for them to get this in place today so that this divisiveness that feeds on itself will stop immediately. In the interim, I think that no phone calls should be taking place between the two of them. Because when these messages are going back and forth, Jaden is undoubtedly standing by hearing it.
Very good. Thank you, Ms. Height. All right, I'll hear from Ms. Powers and then Mr. Brooks.
Thank you, Your Honor. In terms of my family wizard, I think that my client's position is that she would rather just text and doesn't see the need for an additional app. We did do some research, and there is an application through My Family Wizard for a fee waiver or at least a reduction in fee that either party can fill out on their own. In regards to the changes to transportation, it makes good sense to me, but I have not had an opportunity to discuss it with my client, so I'm not sure what her position is.
Okay, thank you. Mr. Brooks.
I mean, the exchanges, as far as the exchanges go, I just simply ask that, you know, she stop trying to get out of the car and start recording us on, you know, like the exchange between our son and her. She gets out and I'm recording you. Well, I'm not okay with that. I'm not okay with her recording the third party or anything like that. If she wanted it recorded, simply she could pull in front of the house and it would be on a hard drive at a children's safe home for men and children, an Oxford home, and they would not show favoritism or whatever. If there was something that needed to be used for the court, they would simply say, here it is. It makes my third party uncomfortable to walk out there and he's on camera. It's not fair to him. Like, I've had to ask numerous different guys in my house to be the third party because they've been talked to foully or mistreated when they were walking down there, and it made them feel uncomfortable where they just opted out and said they're not going to do it. So I'm like down to my last options at the house, where he's like, I'll simply do it as long as she doesn't try to pull me into anything. I'm just simply walking the child from here to there and vice versa. So I mean, there's been some exchanges as far as verbal exchanges where I've simply asked her, I'm like, I'm not giving you permission to record anything, so please stop. And I mean, I think that's been the biggest issue as far as the phone calls and stuff like that. I had her blocked because it becomes harassing. It's just one right after another. Like, she'll call, say something, hang up, call, say something, hang up, send me numerous text messages. No, I don't respond. And if I do respond, it's hard not to feel a certain way where your emotions get into it, where you get a little heated. I admit there might be some immaturity and me responding in a certain way. I try not to respond at all, but I try to keep it open so that we do have some kind of communication for our son if it's needed. But it's getting to a point where it's out of hand. Like, I woke up this morning to 19 text messages from her, and not one of them was about our son. It's just getting to the point. I just simply want him to be active in both of our lives without question. Like, he loves us both. I'm his father. She's his mother. We need to set aside our differences and just simply be parents for him. No ifs, ands, or buts, just be parents to him. You know, if you have certain emotions, you know, they have to be put to the side. I don't hate nobody. I don't dislike anybody. You know, there's an amount of I care because, you know, that is the mother of my son, and we spent time together. We just have a history that ended badly. And it's probably best that we just stepped away from it.
All right, thanks. All right, so it sounds like the parties are struggling, and the parties aren't going to be here forever. They'll be there. Hopefully, there'll be improvements over time. But right now, there's some struggles. With the two concerns that well, number one, I appreciate both parties making good contact with Ms. Height and exchanging information. That's very much appreciated. So thank you both. The issue as far as the exchanges, it sounds like the recommendations from Ms. Height are well reasoned, and I'm going to adopt those. So when Ms. Grandchild Brown is dropping off their child in common, she'll stay in the vehicle. She'll keep her window rolled up. There'll be no communication. And then her third party will escort the child to the gate. And then Mr. Brooks's third party will retrieve the child and take the child into the home where Mr. Brooks will be at, and he'll be behind that closed door. And so there just to be zero communication between the parties at the exchange. That's not a time to be communicating. That's kind of a flashpoint. So we're going to try to eliminate that. And the same thing for the exchange going back from father to mother. Father's third party will take the child. Father will stay inside, door closed. They'll take third party will take the child to the exchange, the fence, and mother's third party will greet the child at the fence while the mother remains in the vehicle with the window up, and there's to be zero communication between the parties during that time frame. And then the mom will take the child to her place. As far as our family wizard, I apologize. I probably inserted some confusion with that. My understanding is that when you sign up, each party signs up separately. You put in your name, you put in your email address, you put in your phone number. The other party will do the same. And then when you're signing up, there's a section to put in the name, phone number, and email of the other party. And then what's the child in common's name? And so then you sign up in that manner. My understanding that the fee waiver comes through the company. You have to go through that process. Otherwise, each party is going to be responsible for their own subscription fee. I would recommend just the lowest level. No need to get up to the $25, $30 a month. I mean, I think there's a $12.50 option per month that each party would be required to do that. And I think that's reasonable given the circumstances. Hopefully, it won't be there forever. I consider it a tool to kind of just train us up right when there's a lot of emotion, and it kind of keeps us focused. Also, you might even want to consider in sending your responses, just remember that everything's recorded through that third party, and that can be presented to the court. You might even use artificial intelligence and just run it through there and do a tone check. How does this come across? And to just kind of modulate, because sometimes it's nice to have a third party say, what does this sound like if somebody was receiving this? You might do that. You might consider that, might not. So I'm going to amend our family wizard portion that each party is required to sign up using their name, their phone number, their email address, and then when you're signing up, then you would also include the email and phone number and name of the other party, and then the child's first and last name. And then you're off to the races. And so you'll each be required to pay that monthly fee. I think the communication at this point will be only by our family wizard. So no phone calls through any other means, or text messages through other means, or through emails through other means. You use our family wizard as the sole communication tool. So that means not sending notes with the third parties. That means not sending it through a third party. That means not using social media. Only communication comes through our family wizard. So I'll draft an order to that effect, and I appreciate both parties working through this. You'll get through this. I think this is just kind of a rough patch, and hopefully with time things will improve. So I'll ask if there's any questions, starting with Ms. Height, then Ms. Powers, and Mr. Brooks.
Your Honor, my one question is, do you have a date in mind that our family wizard should be instituted?
Today.
Thank you.
Today. It needs to be done today. And I'll put that there. By end of today. So I'll say by 10/9 at 11:59 needs to be subscribed by. Okay. Ms. Powers?
I just wanted to make sure that the court is drafting the order, so I don't need to.
I'll draft it.
Thank you.
And then I'll distribute to the parties, and I'll just double check. I think I have the parties' email addresses. I know I have Ms. Heights. I know I have Ms. Powers. Mr. Brooks, what is your email address? If you want to share, if not, you can just jot it down.
CHRIS.
CHRIS. Great. I'll get that out to all of you today. All right. Thank you very much.
I just had one question as far as my third party.
Mhm.
Sometimes the guys that are at my house aren't there.
Mhm.
So me utilizing somebody else that's in the house as a third party so that I can accept my son or give him back. I'm just trying to make it clear, like everybody in my house is very trustworthy. It's a safe environment. Nobody has crimes against children. It's a men and children's home, or they wouldn't be there. I just simply ask that the court put it in place that if the person that I've been using as my third party, if he's not there, that it is okay, and she can't pick and choose who's going to be the third party. Like,
Yeah, each party chooses their third party for the delivery of the child.
I'm just saying, could one of the gentlemen his mother's having some issues and he could be leaving at any time and not be there for that exchange, but I could still utilize somebody in my house as a third party. Just trying to make it clear. Sometimes it's not the exact same person. I live with 9 other guys.
Right. Ms. Hyde, any comment on that? Looks like you're muted still. Let's see. Ms. Hyde, can you hear me okay?
Yes.
Oh, there you are. Do you have any comment?
No, I'm clear on that now. Thank you, Your Honor.
Okay, thanks. Ms. Powers, any comment?
I know that one of the third parties that was being utilized had conflict with my client. My hope is that now that both parties are not going to be coming out for the exchange, that should hopefully take care of any concerns that were present prior.
Great, thanks. Yeah, I think that's fine. Mr. Brooks can choose the third party to deliver the child and receive the child. And so, very good. Thanks, everybody. Appreciate your help and cooperation.
Thank you.
Thank you, Your Honor.
Thanks. Number, and I'll ask if Brian Nash is on the line. Brian Nash.
Yes, Your Honor, I'm here.
Okay, welcome to you. And then Tara Nash, are you here?
Yes.
Very good. Welcome. And then Ms. Looney, I see that you're present.
Yes. Good morning, Your Honor.
Good morning. All right. So as far as today's hearing, I have proposed orders that have been supplied by the parties, and it looks like each of those orders has been signed by both Mr. Nash and Ms. Nash. And we have Ms. Looney present also. So I'll tell you what I have in my possession. I have a findings and conclusions about a marriage. I have a final divorce order. I have a parenting plan, child support order, and child support worksheets that have been signed off by each of the parties. So I'll just double check to make sure first with Mr. Nash and Ms. Nash if you're comfortable with those proposed orders. Mr. Nash?
Yes, I'm comfortable with everything. We've kept in good communication. Everything seems okay.
Okay. And Ms. Nash, are you comfortable with those orders as presented?
Yes.
Okay. I'll ask Ms. Looney if the state has involvement or requests related to child support.
We do, Your Honor. I did review the parties' worksheets and support order. There's just a few pieces missing that the state would ask to be completed that were left blank in the order.
Right.
So the first would just be section 5. That's on page 2. There's a section that requests whether or not the parties have overtime. That just piece was left blank. We just asked that be marked no. The state's not aware that anyone is working overtime or a second job for either parent.
Okay. And then Mr. Nash and Ms. Nash, do you see where do you have that child support order in front of you on page 2? It's kind of about 3/4 of the way down. It says, does this parent have income from overtime or a second job? She's recommending that no be checked on both of those boxes for both parties. Mr. Nash, any concerns with that?
No, Your Honor. Neither of us that I know of has been working any overtime, so that's fine.
Thanks. Ms. Nash?
Yes, that's fine.
Great. I'll go ahead and mark both boxes on section 5 as no. Ms. Looney?
The next section we were wanting to request a slight change to would be section 11, which is on page 6 and also goes over onto page 7. The parties, according to their calculations with the state, is also in agreement with, have a standard calculation of 0 payment. They have a start date of June 24th, and then they have marked 1 payment each month with the day left blank. The state would just ask that instead of having a payment day per month, that other be marked and that no payment required be interlineated on that section, just to make it clear that there's no payment that needs to be made on a specific day.
Mr. Nash, any concerns with that adjustment?
Sounds great. I just wasn't sure which one to check.
Sure. Ms. Nash, any concerns on your end?
No, that's totally fine.
So I'll remove the X in the first box under paragraph 11, and under the other, I'll write no payment required.
Okay.
Great, thank you. Ms. Looney?
We only have 2 more sections. The next is section 20 regarding medical coverage. That's on page 11.
Okay.
It's on, sorry, page 10 and 11. The parents had marked that was not being ordered, how medical support needed to be provided. We do have the children enrolled in public health care currently, so we just asked that in addition to that, we just mark that public health care coverage is provided by the mother. Our understanding is that some of the children will no longer be living in Washington, but that will also show that the 4th child is covered by state medical here in Washington.
Okay, so your proposal is to leave the box that's currently marked, to either leave that as is or remove that, and then mark the public health coverage.
Yes, we would ask to take the first marking out. I apologize, Your Honor. Unless one of the parents is providing private health insurance as well, then we would ask that that be included if that is being done.
Okay. Mr. Nash? Your thought?
I currently don't have private health insurance, Your Honor, as we're transitioning kind of between where the children were living and now they'll be living with me. I planned on getting them enrolled in healthcare coverage here in Idaho, where I'm living now, but it just hasn't happened yet.
Okay. Ms. Nash?
I'm okay with it staying the way that it is.
Okay. And so, Ms. Looney, just to clarify, if the box that's currently marked as omitted or removed, then you're asking for the public health coverage, and that where it would read, Ms. Nash has enrolled the child in public health care coverage and does not have available at no cost accessible health insurance through an employer or union. That's what you're asking that one to be marked?
Yes.
Yes, Your Honor, and that
Okay.
the other parent must enroll the child in accessible health care would also need to be indicated.
Okay. Any concerns with that, Mr. Nash?
Sounds great.
Okay, so that would be the first box, which is public health care, and then it'd be Tara A. Nash. I'll write in there. And then the second box just below that, you're asking Ms. Looney, that's the box that you're addressing and or proposing should be marked.
Yes, Your Honor.
Okay, very good. I'll remove that first box under 20. And I've made those 2 adjustments. Okay, next item or section.
The last piece, Your Honor, is just that in section 22 on page 12, there's proportional shares indicated for uninsured medical expenses, but the parties just neglected to put where the payment needs to go. So we would just ask that be completed according to what they would prefer.
Oh, I see what you're saying, where it says uninsured medical proportional share, and then the person to whom to make the payments, whether it's the person who pays the expense or to pay it to the service provider. That's what you're referencing, correct?
Yes, Your Honor.
Okay. Mr. Nash, do you have a preference as far as that proportional share when there's expenses related to uninsured medical expenses? Are you wanting the order to say that you pay the other parent or that you pay directly to the service provider?
I really have no preference. It doesn't matter to me. Either way works. We've been really good in communicating and working what's best for the children. So either works for me.
Okay. Ms. Nash, your ideas?
Yeah, that's fine. Either one is okay with me. We both work pretty well with the kids and we try to always put them first, so it'll be fine either way.
Okay, I'm going to mark service provider. So the proportional payment would be to the service provider. That way there'll be a third party that receives the money, and then they keep an accurate record of that.
Okay.
All right. Anything else, Ms. Looney?
No, Your Honor, that was the only one, or the last one, sorry.
Okay. All right. And let me touch base with Mr. Nash or Ms. Nash. Do you have any other questions or concerns related to the orders that have been presented today? Mr. Nash?
I don't really have any other questions for the orders. I guess my question is more along the lines of the state medical getting them transferred. If they're currently on the medical in Washington, do we have to remove them from that medical before I apply for the Idaho medical?
Great question. Ms. Looney may have some insight as to that.
Your Honor, I am not sure if that would need to happen or not, but the best thing they can do is just contact either the Division of Child Support or Social and Health Services and ask them what needs to be done. I know they do need to notify Social and Services if the children will no longer be getting that medical coverage, so that they can do what they need to do on their end to stop that coverage for a specific date.
Okay. All right. Yeah, Mr. Nash, I don't have any specific answer to your question, and sounds like Ms. Looney has offered up some suggestions, and hopefully that will be of assistance to you.
Understood. Thank you very much.
Ms. Nash, do you have any questions?
No.
Okay. Well, let me just say I appreciate both parties working through all of these issues and being good communicators and coming to an agreement that you both feel relatively comfortable with, and that bodes very well for your children. Those children will be yours forever, and thank you for working for their best interest. Appreciate it. So I'll go ahead and sign off on each of the orders that have been presented, and those will be filed today. If any party needs a copy of a filed order, you can certainly contact the clerk's office and request a copy. Otherwise, I've signed that, and we'll terminate the hearing for today.
Thank you, Your Honor.
Thank you.
Why don't you come on up so the microphone can grab you?
I leave the courtroom. She's already blowing up my phone with nasty text messages, and then the end one is, "I'm blocking you for good."
Okay.
Like she won't stop. I don't contact her. I go to work. I spend all day at work. I have responded to text messages, but I don't just start my day with like, I'm gonna get up in the morning and I'm gonna text you a bunch of nasty things and leave nasty voicemails to you. I
Okay.
just wanted it to be documented, like I didn't even get out of the courtroom and my phone's already blowing up.
Okay. All right. Thanks. All right. Looks like we have. Okay. All right. Ms. Martin is present. All right. And then is Stephen Martin present?
Yes.
All right. Right, Mr. Martin, could you do me a favor and turn on your camera, please?
Kirby's not even in it. Kirby's not even in it.
Probably in person.
Come
Good morning, Your Honor. Amanda here on behalf of Megan Rhodes.
Really so. Right, Mr. Lawrence, where do we stand?
Well, Your Honor, I was appointed as guardian ad litem in this matter on September the 18th. I made home visits to Ms. Hayes' home, Jonathan's home last week. I don't have all their paperwork back yet. We just are getting started on the matter, but both are cooperative and working with me on this. And so that's pretty much all I have to report at this time.
All right, do we need to set another review date, or should we just leave it to the parties to note up when it's ready?
Your Honor, I believe this is Rhodes v. Jensen, correct?
Yes.
Yes, we are, forgive me, we are on for presentation of orders on this one. Mr. Lawrence has already completed a very thorough GAL investigation, and now we are on for presentation of orders and for review of child
Hang
support.
on, let me stop you just a second.
We're on Donovan v. Hayes, correct? Okay. Number 9, Donovan v. Hayes.
Around about how far you want to cut.
Mr.
Around it.
Okay, whoever is doing all the talking, please wait till it's your case. Okay, that's what everything was reserved. I don't think we need any further review date at this point.
I don't either.
Okay. And we have Ms. Hayes anywhere? Oh, there you are. All right. So both of you continue to follow up with Mr. Lawrence, and I'll leave it to both of you to note the matter back on when you think it's ready.
It was set for 12/16, Your Honor, December 16th.
December 16th?
This matter is set for December 16th for what I believe is the GAL review.
Right. Just final GAL report due then. Okay. All right.
Thank you.
Then nothing further today on that one. You had one other, didn't you?
Yes, it's the Rhodes v. Jensen matter. Ms. Holder was referring to that earlier. And I believe we're here for a presentation of order.
Do we have Mr. Jensen?
Yeah, I'm here.
All right, Mr. Jensen, I've got some proposed orders that don't have your signature on them regarding child support.
Yes.
Parenting plan. Are you in agreement with those orders or not?
No, not the child support. And then I had spoken to Amanda a couple times now about the parenting plan, paragraph 4. I believe that it's not what the judge had said. I believe it says that just I'm not allowed to drink within 8 hours prior to getting Nora, but I think it's supposed to be both parties. And then number 8, it was paragraph 8 in the parenting plan was a little weird. I think it says when Nora starts kindergarten, it shall remain week on, week off, starting Friday after school until Sunday evening, and with every other week, every other Wednesday.
Okay, well, let me stop you for just a moment. So it looks like we are not in agreement. This was heard by Judge Evans, so the presentation is going to have to take place in front of him. Does he have a regular calendar, or is this going to have to be special set?
No, this is his one. So if you want to continue to different week on.
Any reason we can't put this on for next week, the 23rd at the same time?
Yeah, that works.
Ms. Holder?
Checking my calendar right now. I believe on the 23rd at 9 a.m. I do have a hearing, so I will already be on the docket. I'm fine with that.
On our docket, you mean? Or elsewhere?
Yes, Your Honor.
Okay, so the 23rd at 9 o'clock. Mr. Jensen, it would be extremely helpful if you would submit in writing what your issues are with the orders. Make it much easier for the judge.
All right, thank you.
All right. You want these? Is that it for you?
That's it. Thank
All
you,
right.
Your Honor.
Thank you. Mr. Davis, anything you want to add to what you've submitted?
I don't believe so.
And Ms. Davis, the issue regards a quitclaim deed that hasn't been signed. What's the concern?
He has had the papers and he keeps telling me that he'll get it to me so I can sign it, and he hasn't. And I've asked him numerous times for it.
All right, have you got the proposed quitclaim deed?
I do, sir.
Well, then why don't the two of you go out and we'll get everything taken care of, and we can come back to the case later in the docket. Shannon Johnson and Kenneth Johnson. Sir, the request that was made was to transfer this to mediation. Any objection to that?
Yes, so we have a pending GAL review with everything going on. I have a DDPO already, so it's gonna have to be shuttled one anyway. There are some things we can agree upon, but I don't think I've never been served anything anyway, so I don't really know what she's asking. I don't think everything can be resolved with mediation. Or I know it will not be.
All right, well, as Ms. Johnson is not present, I'll strike the matter for today. She can note it back on if she's still making that request. Okay, that'll be all.
Thanks.
Nicholas Davis and Holly Ann Davis. Those are the two I just sent out. Okay. Lirinell Martin and James Martin. Okay, it looks like everybody has signed off on.
Your Honor, Casey Linney is present on behalf of the state for child support as well via Zoom.
And I've got signatures on the decree and those matters. I don't have signatures on the child support order or the worksheet, it looks like.
Yes, Your Honor, the state has provided a proposed child support order because the parties had left some information out of the proposed order that we received. And there's also some incorrect information regarding medical insurance that the state would like to have corrected and addressed.
I have paperwork with me.
I'm sorry, what? I couldn't hear you.
I have paperwork with me. I'm not pretty sure if these are the correct ones, but it is regarding.
Pass that up to the clerk, please. So I do have those, looks like dated 9/27, council and both parties have signed. So are those the current ones?
I'm just checking, Your Honor. Yes, the orders that we proposed would be signed by me on 9/27. If both parties have signed off on that, there are some blank spaces that we did leave in that we would like to confirm whether those are still blank or if the parties have filled those in themselves.
Well, and I'm just looking at the other ones. Unfortunately, I've got two sets, both dated 9/27.
Okay, there should be one set dated 9/27 that our office drafted. If there's one that the parties drafted themselves, that's separate. The state has not seen that.
Yeah, both these sets are signed by you. I'm
Okay.
not sure if there's any difference in which is which.
There should not be the 9/27 that would be potentially signed by the parties. My signature would be a photocopy. And the other would be an original. And that would just be the copy we provided for the court today, Your Honor.
Okay, but it's, from your standpoint, the set dated 9/27 has the correct information in it.
It should, but we have left the deviation section blank as well as the payment amount because the parties had originally indicated that another court had ordered a $498 payment amount. Standard calculation that we got from the incomes that we calculated from the employment security data would have a standard calculation of $725. We did leave the deviation section if the parties had wanted to make the argument to change that number. But if they have not, we would ask that it be amount that on section 9 on page 3, it be marked that there's no deviation and no one asked for one. And then on page 10 or 3, section 10, section 10, we would just request that the amount of $725 be filled in for the support.
And ma'am, it looks like you're both in agreement with the $725 number. Okay, it looks like we don't have the final testimony here. So, ma'am, go ahead and have a seat. And if you'll raise your right hand, please. Do you swear to tell the truth in this proceeding? And would you state your name, please? State your name for us, please.
Can you say it again, please?
Would you state your name, please?
Lironel Martin.
So you were married in 2012. You have one child, correct?
Correct.
And separated in 2021.
Yes, Your Honor.
And is this the parenting plan that you've been following? And has that been working?
Yes, correct.
And you divided up any and all property that you have?
Sure.
Is your marriage irretrievably broken?
Yes.
Bring to degree. Thank you, ma'am. Landon Floyd and Cassidy Cram.
Ann Height, guardian ad litem, Your Honor.
And have we got any contact with either of the parties?
Yes, Mr. Floyd has responded, and I have actually met with him and met his little 1-year-old daughter. I have had no compliance whatsoever from Miss Cram. She hasn't responded. I've verified her phone number and her address and resent and remessaged multiple times, and I've had no contact from her. So my only option at this point seems to be to move forward with what is going to be a one-sided report, Your Honor. She has moved from this area to Oregon, which is more than 200 miles.
And he has custody of the child at this point, correct?
They are actually exchanging the child a couple of times a week for that long drive, which I find troubling.
Okay. Well, at this point, we are on for December 16th for your report, so I think we'll just leave it there.
Okay, Your Honor, thank you.
Thank you. Damon Woodhams and Samantha Woodhams. Ma'am, I have read what you submitted. Anything else you want to tell me about? In addition to what you already submitted?
So I have also submitted the temporary parenting plan. Yesterday was when I did that, so I will need to serve him with that through a third party. I know he did request mediation at our protection hearing docket, which, you know, I was in favor for. But then I found out right after that protection hearing docket that the restraining order did go through. So they did, when I spoke to the mediator, she did let me know to probably seek some legal advice. And I did want to see what we can do right now, if we could get a GAL appointed possibly for our case. I know we have the Wizard app, so he can begin to speak and see the children. I do believe that, you know, it is in the best interest for supervised visits at this time, or to figure out what would be in the best interest for the kids.
So is there another restraining order or protection order in a criminal case, or?
We have the protection order through the protection order docket, and then I submitted the restraining order as well through the family law.
Okay, and then what's that other protection order have to say?
The protection order was for when the assault occurred on 9/5.
Okay, so is that in a criminal case, or was it a separate civil file?
It's in a civil.
Okay, and does that prohibit all contact between the two of you, or what's?
Yes, it did, and that's when Judge Carney, she did say that we could do mediation.
Okay. So what is it that you are requesting today?
I would like to have the restraining order in place for the protection of I and the children. And then as well, until we can get the parenting plan situated.
All right, and are there charges pending?
Not that I am aware of, other than for possibly him breaking the protection order and trying to contact me.
All right, sir, what's your position?
I have a ton of evidence right here with me right now. And all the false allegations that have been ran through.
Okay, well, the problem is you haven't filed anything.
I haven't been able to. I work graveyard. So it's been just a challenge to get here at 9 o'clock today. I filed a protection order right after she did at the same time. Let's see here. So I was the one trying to stop her from taking off because she had either been intoxicated or.
Okay, let me stop you a second. The problem I've got is that you haven't filed anything in response to what she submitted in this case. Okay, and you're telling me you've got a bunch of stuff you want considered. That's obviously not going to happen today.
No.
All right, I'm going to leave the order in effect. The temporary order that was entered 9/27. I'm not going to make any changes to that. We're going to put this over for 2 weeks. That's to October 30th. You've got to get whatever your response is filed. You've got to have a copy served on her so you can file any response you want to. But we can't go forward if you don't do that. You understand that? All right, the 30th at 9 o'clock. And sir, you understand the order? Take your hat off, please. You understand the order from September 27 is still in effect. That'll be it. Hey, take your hat off, please. Oh, didn't. Okay. That will be all. Let's go back to the Davis and Davis matter. Where are we now? Okay.
Also need to have her sign the 8332 form for taxes.
And is that an issue, ma'am?
Mr. Davis and I had a verbal agreement that I would claim our son for 2023.
But in the court order, it clearly states that I got odd years 23, 25, 27. The last year that I was able to work.
Well, ma'am, that's what the support order says, is he's got odd years and you've got even.
Okay.
So I think you need to get that signed as well. Okay. All right. So we'll take one more shot at it. If you go ahead and step out and get that paperwork done, we can come back to it. Christine Whips and Anthony Whips. And sir, it looks like you haven't filed any kind of response at all. Is that accurate?
Your Honor, I asked my parents because I had to leave the country for medical care, and I won't be back till November 1st. And I had emailed all the paperwork to my parents to turn into the court and serve my kid's mother. However, they were unable to do that. And my friend who attempted to, they said because he got there after 4:30 p.m., he wasn't able to file them either. So if possible, I'd like to request a continuance.
What's your position on that, ma'am?
I would like to just continue this as is. He has left the country for his own purposes for the last almost a month. So, and I was served him before that. Therefore, he has had time before he left the country even to do this.
The reason why I didn't file it before was because she filed an amendment after I left the country, and I was unable to get it signed that I had been served that while I'm overseas.
Well, according to what I'm looking at, you got served with everything on September 18th.
Yes, Your Honor, and I have that paperwork all signed and it was ready to turn in, and then I had to leave the country for medical care.
Well, I'm having a hard time understanding why that prevented you from responding to any of this. Especially if you said if you had it all filled
The
out.
emergency medical care.
No, if you say you had it all filled out before you left, what's the issue?
The issue was I was prepared to turn that into the court and serve my kid's mother. However, I have bipolar and I had a hypomanic episode. And during that episode, I sought medical care. I was unable to get a bed locally. I tried to go to Calgary, Alberta to get a bed, and I wasn't able to get one until November, and was able to find a place in Jamaica that with a TRN number was able to give me free medical care. So I came here for medical care.
Okay.
And I have a flight home on October 31st and will arrive in Seattle at 12:30 p.m. on November 1st. And 2 days ago, I had a psychiatric evaluation, and I had that paperwork ready to submit and had sent it to my parents, but they were unable to deliver it to the court.
Ma'am, do you have proposed orders with you today?
I would like to still get those so that I have sole custody for motion for.
Do you have proposed orders to present today?
The ones I submitted, I don't understand.
When did you submit those?
I don't know. I thought all the papers that I submitted were the proposed orders.
She didn't file.
We've got proposed order parenting plan filed, but okay. We'll have to come back to this. We'll take care of the other cases. We'll take a break. We'll need to burn a copy of that so we can get something signed today.
Orders.
Do you have a proposed parenting plan, a copy with you?
Yes.
All right. If you'd hand that up to the clerk, please.
I personally don't have a problem with what she put in the parenting plan. My main concern was not being able to submit my declaration page and statements.
Okay, hang on just a minute, and I think we can get us sorted.
Yes, Your Honor.
For the near-term future.
Is it the information for the parenting plan?
No, it says proposed. What you submitted says proposed parenting plan. I need a copy of that.
Sorry, I don't have that ready. I have the parenting plan paper, just says parenting plan.
Parenting plan is the one I'm looking for. Yes.
I have a digital copy of it, Your Honor, but I don't think I'll be able to submit it now.
Okay, so that we've got something in place, I am signing this proposed parenting plan indicating the visitation is as agreed between the parties. And it's good through November 13th. I'll continue the matter to November 13th on the same docket, 9 o'clock. Excuse me. No, November 11th. Okay, pardon me. So, sir, you need to get your response filed and served prior to that. You understand that?
Yes, Your Honor. I have, I'll be home on November 1st and I could bring it in the next day.
That would
what
be
is the deadline?
Oh, I'm sorry.
No problem.
Okay, so the 18th, pardon me.
The court, that's the deadline or that's the court date?
That's the court date is the 18th.
Okay,
that's at 9 o'clock. Get everything filed and served by the 5th.
Yes, Your Honor.
Oh, and it's at 1 o'clock on that date? Okay. Did you? I'm sorry, I didn't realize it's on the 18th at 1 p.m. You understand that, sir?
Yes, Your Honor.
And you got that, ma'am?
Yes, I do.
All right. The 18th at 1 o'clock.
Your Honor, can I ask one more question before we're finished?
Yes, sir.
So when my wife asked for the separation, she had control of all of our finances, including my children's savings account, our joint savings accounts, and my paycheck, which she moved to a new savings account that I have no access to. So I will have a paycheck at the end of this month. However, I've been living on a credit card since I left.
So what's your question?
Is there any temporary order that you can have, even just splitting the liquid assets on hand or anything like that at this time, or do I need to wait till the 18th?
We'll need to address that on the 18th after you've responded and she's had a chance to see what you need.
Yes, Your Honor, I understand.
All right. That will be all.
Thank
Thank
you.
you, Your Honor.
So is everything signed?
Yes.
Okay. Anything else we need to address?
The quitclaim deed, it has to be notarized.
The what? The quitclaim deed?
Right, it needs to be notarized.
Mhm.
That,
No. I don't know that there's a notary in this building. Probably the best place to go is to the bank. So can both of you meet at your bank or credit union and get it done there?
Yeah, we have to find a place like, my bank doesn't do the notary anymore.
Okay. The other option would be a title company.
I believe UPS has some too.
Okay. Well, before you leave the building, agree on where you're going to, and so you can get that taken care of.
I do have a few more questions though.
Yes, sir.
She has informed me that she's gonna claim our son for every year for taxes because I'm currently not working.
With the order says what it says. If anybody wants to change that, you can bring a motion.
Yes.
Okay. All right.
Thank you, sir.
Thank you. Amy Humbird and David Roderick.
Thank you.
All right, Ms. Humbird, I can see your lips moving, but you're muted. You're still muted, ma'am.
Can you hear me now?
There we go. Okay.
Good morning, Your Honor. Barbara Russell from the state of Washington.
Yes, ma'am. All right, and Ms. Humbird, this is on the state's motion to set child support. Have you got any objection to what they propose?
No.
And Mr. Roderick, I see you there. Do you have any objection to what the state's proposed?
In the amount of what they're asking me to pay?
Yes, sir.
No, I don't.
All right, then I will sign those orders.
Thank you kindly, Your Honor.
Natalie Morgan and Andre Doherty.
Hello.
Ms. Doherty, I haven't received any response from you. Effective service wasn't made on you until the 12th. So we can only go forward today if you want to go forward today. Are you ready to proceed, or would you rather continue the matter?
This is for the parenting plan, correct?
Hang on. So, ma'am, do you want to proceed today, or do you want to continue this?
If we could proceed today.
Okay, and I don't have any kind of a response from you to what's being requested.
Yeah, I was actually the person that
Mr. Doherty?
Yes.
Hang on.
Gotcha.
Your Honor, this is Barb Russell from the state again. The state will be entering an appearance in this matter. It has not yet. So I would ask that it doesn't look like they're addressing any support issues today, although there is a request for support in there. I would just ask that any support issues be reserved.
All right, thank you.
Your Honor.
And I apologize, Mr. Doherty's the one who didn't get served until the 12th. So I don't have any response from you, sir, but as I said, this effective service wasn't made until 4 days ago.
Correct.
So where are you at in terms of proceeding today or continuing the matter?
Continuing, please, so I can get legal counsel on this.
All right. Ms. Russell, how far out do you think it's going to be for you to get the child support issue resolved? Or
It doesn't look like there's any motion, or it's in the petition requesting for child support, but there's no motion for it. So I can file my own motion, but I'd need at least 3 weeks for service. I could get it filed this week.
Okay.
Under local rule 88.
All right. And Ms. Morgan, I apologize. I had the names reversed initially. So Mr. Doherty wasn't properly served until 4 days ago, and he's entitled to more notice than that. So
Absolutely.
we need to move this out a little ways. Sounds like the prosecutor's office is asking for 3 weeks. Does that work for you?
That does work for me. Further documents that possibly need to be served. I have no way of being able to locate Andre. So
Okay, well, let me tell you what's going to happen next.
Okay.
Since he has been served now with paperwork, he needs to file a response.
Okay.
That response has to include where he's at for purposes of service of papers. So if you have more stuff after you receive that, if you have more things that you want to file with the court or serve on him, you'll have an address there that it can be mailed to.
Okay,
Understood?
understood, Your Honor. Thank you.
Okay. So what's the date going to be in 3 weeks?
Fourth at 1 p.m.
Okay, November 4 at 1 o'clock.
Okay,
Okay, so sir, you need to get your response filed with the court and served on her ASAP. Understood?
November 4th, 1 o'clock.
Yeah, but you got to get it filed well before then. That's just the date to come back.
Correct.
Okay. Where are we right now in terms of contact with the children from your standpoint, ma'am?
me.
Yes.
I currently have a granted protection order.
Is that in a criminal case or through a separate protection order proceeding?
A separate
Okay.
meeting.
And is that set for hearing?
It was already finalized on September 23rd.
Okay, so there is no subsequent hearing pending on that?
No, sir.
Okay. All right, then we will continue this matter over to November the 4th at 1 o'clock. Get your response filed right away, sir, and sir. Understood?
Understood.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
I think that is your calendar.